Good afternoon. I'm Anna Hughes, and over the next 30 minutes or so, I'm going to explain what the Supreme Court decided in the joint appeals in Paul, Palmer and Purchase, what this means for secondary victim claims in the clinical negligence context, and what the criteria are now for bringing a secondary victim claim in personal injury cases. I want to begin by looking briefly at what came before the Supreme Court's decision last week, as understanding the background to these three cases is essential in order to properly analyse where we are now. The decision in Paul represents a seismic shift in the law governing secondary victim claims, and so, as all good judges should in such circumstances, the leading speech of Lord Legate and Lady Rose begins with a detailed history of how the law in this area had developed prior to their decision in Paul. Those fans of legal history amongst you are advised to consider the early paragraphs of the speech at your leisure. But for our purposes, and conscious of the fact it's a Friday afternoon, we won't dwell on the same. We will look, however, at the key decision which, prior to Paul, had been the leading authority in this matter. The case of Alcock, arising out of the Hillsborough disaster, set out the key legal hurdles one needed to clear in order to bring a secondary victim claim. Various family members and loved ones of those killed in the Hillsborough tragedy brought claims in their own right for psychiatric injury they understandably suffered either from being at the grounds or witnessing the horrific events unfold. None of the claims succeeded. But the House of Lords confirmed that the criteria that a claimant needed to establish in order to show that the defendant owed them a duty of care in circumstances where the primary victim of the defendant's negligence was another person. Those criteria were, firstly, a close tie of love and affection to the primary victim. Secondly, proximity to the event or its immediate aftermath in time and space. Thirdly, there had to be direct perception of the event or its immediate aftermath. And fourthly, the individual concerned had to have suffered a recognised psychiatric injury which was either caused by or induced by a sudden, shocking event. And finally, it had to be reasonably foreseeable that a person of normal fortitude may suffer psychiatric injury due to shock. Now, when each of the cases in Paul, Palmer and Purchase began, the battleground between the parties was the need to establish proximity. In particular, the dispute centred on what it was that the secondary victim needed to be proximate to. All three were cases in which the claimants alleged that a breach of duty on the part of a clinician occurring some time prior to the eventual death of their loved one had caused the death of that loved one. They all claimed that witnessing the death, or in the case of Purchase, the immediate aftermath of the same, had caused them to develop a recognised psychiatric injury. The claimants in Paul were the young daughters of Mr. Paul, who had been admitted to the defendant's hospital with cardiac symptoms in November 2012. The claimants alleged that the defendant's staff negligently failed to diagnose their father's ischemic heart disease and occlusive coronary artery atherosclerosis. On the 26th of January 2014, Mr. Paul was out shopping when all of a sudden he took ill and collapsed. By all accounts, the scene was sudden and shocking, and the claimants were understandably distressed. It was said on the claimant's behalf that Mr. Paul's collapse was the first manifestation of the defendant's breach of duty, and that as a result of witnessing this event, they both suffered psychiatric injury. The defendant successfully applied to strike out the claim on the basis that there was no relevant event, as the heart attack was not capable of being legally recognised as such for the purpose of determining proximity. Further, it was held that as the negligence in this instance was in 2012, the requisite degree of proximity on the part of the secondary victims to establish liability was absent. In reaching his conclusion on Paul, Master Cook felt that he was bound by the earlier decision in Taylor and Somerset Health Authority. In that case, the claimant's husband suffered a heart attack at work caused by the defendant's negligent failure months earlier to diagnose and treat his serious heart disease. He died shortly after being taken to hospital. The claimant went to hospital where she was told of her husband's death and identified his body. Mr. Justice Auld found that in order to recover damages, the claimant needed to show that there was an external traumatic event as a starting point in order to consider proximity. The claimant in Taylor had argued that the death constituted the event, but Mr. Justice Auld dismissed the claim as he stated that what the law requires is an external traumatic event caused by the defendant's breach of duty, which immediately causes some person injury or death, and perception by the claimant of that event as it happens, which is usually by presence at the scene or exposure to the scene and the primary victim so shortly afterwards that the shock of the event, as well as of its consequences, are brought home to them. It was found that there was no such event in Taylor. On the contrary, the heart attack was simply the final consequence of the deceased's deteriorating heart condition. Master Cook saw the parallels between that case and the facts in Paul, and thus struck the claim out. The claimant's appeal in Paul was heard by Mr. Justice Chamberlain. He approached his task by performing a comprehensive analysis of the case law in this area. It is of note that having performed this review of the relevant authorities, the judge prefaced his decision by acknowledging that they demonstrated a degree of frustration about the lack of coherent principle underlying the law governing claims for psychiatric damage suffered by secondary victims. Nonetheless, he went on to provide what he felt would be some clarity on the topic. The first point to emphasise, and this is really important, is that proximity is used to mean two different things when it comes to secondary victim claims. Firstly, as with any claim in tort, in order for a claimant to successfully argue that a duty of care is owed, in line with the neighbour principle established way back in Donoghue and Stevenson, a claimant must show proximity to the defendant. When it comes to secondary victim claims, one determines that broad question of whether there is proximity between the claimant and the defendant so as to give rise to a duty of care by looking at whether the claimant can bring themselves within the control mechanisms that had been set out by the court in Alcock. The second use of proximity in secondary victim contexts is that when one then goes on to consider the Alcock criteria, the claimant also has to show that they can establish proximity to the event or its immediate aftermath. So Mr. Justice Chamberlain explained that when he was considering proximity in the Paul context, it was part of but distinct from the more broad, wider question of whether there was any general proximity between the parties. Turning to the specific matters before him in Paul, he began by noting that the requirement is for proximity between the claimant and the event, not the negligence which gives rise to it. He also rejected the defendant's argument that to establish proximity to the event, the claimant had to demonstrate proximity to the scene of the tort. The judge then went on to consider the defendant's secondary submission based on Taylor and Somerset, namely that a heart attack was not capable of constituting an event that could give rise to liability in this context because it wasn't external or traumatic. He dismissed this argument by asserting that there had been a misunderstanding as to what external event meant in that context. Mr. Justice Chamberlain remarked that if the defendant's reading of it was accepted, namely that the event had to be external to the primary victim, then this would preclude recovery in all cases where the injury to the primary victim was caused by a negligent clinical omission, as those events would never be external to the primary victim. He stated that the proper reading was therefore that the event had to be external to the secondary victim. This meant that in Paul, the heart attack was a proper event because it was external to the claimants. He went on to explain how he considered that his decision was consistent with the Court of Appeal decision in Taylor and De Novo. Now, you will all recall that that's the case in which the claimant's mother sustained an injury to her head and foot when a fellow employee caused a stack of racking boards to fall on her. She seemed to be making a good recovery, but 3 weeks later, she collapsed and died as a result of deep vein thrombosis leading to pulmonary embolism, caused by the original accident. Her daughter, who was the claimant, did not witness the original accident, but did witness her mother collapse and die at home, and as a result of that, she developed post-traumatic stress disorder. Again, the question for the court was whether the claimant could rely on the death at home as the irrelevant event for the purpose of establishing proximity. The claim in Taylor was dismissed. Mr. Justice Chamberlain stated that the reason why he felt it was dismissed was that the event in that case was the falling of the crates, and there could only be one event, and the claimant hadn't witnessed it, as opposed to the decision that actually a collapse was never capable of amounting to an event. So for all of those various reasons, he allowed the claimant's appeal in Paul. The second case before the Supreme Court, Palmer and Royal Cornwall Hospitals, was decided after Mr. Justice Chamberlain's decision in Paul. The Palmers were the parents of Esme, who when she was 6 years old was investigated by the defendant's paediatricians on account of episodes of breathlessness. No cause for the episodes was found, and she was discharged from the clinic in February 2015. Sadly, the episodes continued, but before she could be seen again, she collapsed at school and died. Both parents were present during resuscitation attempts, and again, it was accepted by all involved that the circumstances were tragic. The cause of death was negligently undiagnosed pulmonary veno-occlusive disease. In Palmer, the defendant's argument that the claim should be struck out because, in line with Taylor and de Novo, the death occurring 5 to 7 months after the negligent failure could not satisfy the proximity control mechanism. But Master Cook refused to strike out the claim. And the final case was Purchase, and that involved the death of a 20-year-old woman from pneumonia, which the defendant had negligently failed to diagnose some days earlier. Her mother, again the claimant, found her body minutes after she had died, and the mother developed PTSD as a result of this. District Judge Lum in Birmingham struck out the claim, but he had not had sight of Mr. Justice Chamberlain's decision in Paul prior to so doing. All three cases were heard together in the Court of Appeal. The Court of Appeal disagreed with Mr. Justice Chamberlain's analysis of Taylor and de Novo and found that that case precluded recovery in all three appeals in Paul, because the Court of Appeal in Paul said that Taylor and de Novo established that where a secondary victim witnessed a horrific event causing injury to a primary victim, but that was separate in time for the negligence, then there could be no recovery. Interestingly, 2 of the 3 judges in the Court of Appeal expressed the view that, left to their own devices and allowed to start anew, they would have rewritten the law so as to permit recovery in all 3 claims. Well, if and insofar as that was intended to act as a shot across the bows to the Supreme Court, it failed spectacularly. Having set out that the key issue raised by the appeals was whether the secondary victim claims should be permitted in cases where the claimant has witnessed the death of a close relative, not in an accident, but rather as a result of a medical condition which had not been diagnosed, the Supreme Court in Paul found by a 6-to-1 majority in favour of the defendants in all 3 cases. As I've mentioned, the leading speech was given by Lord Legate and Lady Rose, with whom Lords Briggs, Sales and Richards agreed. They approached their analysis in 2 different ways. Firstly, they approached it as the claimant's lawyers had urged them to, i.e. by examining the case law in the area in order to determine whether the cases before the Supreme Court either ought to succeed on the basis of the existing law or alternatively by way of an incremental extension to the same. And secondly, they approached it as urged to by the defendants, namely by considering whether a doctor who provides medical services to a patient owes a duty of care not only to that patient, but also to the close members of the patient's family to protect them against a risk of injury that they might suffer from witnessing the harm caused to the patient by the doctor's negligence. Note, this was not canvassed at all in the lower courts. The dispute in the lower courts focused firmly on the need to establish proximity. The majority in the Supreme Court concluded, looked at from either standpoint, the claimant's claims were bound to fail, and they were therefore struck out. Turning to the first approach, requiring analysis of the case law, it was stated that the issue as to whether the secondary victims could recover damages absent an accident had not actually been decided in any of the House of Lords cases on secondary victims prior to Paul. Lord Legate and Lady Rose identified their task as having to determine whether what was decided in those earlier House of Lords cases involving accidents could be applied in cases of medical negligence, where there was no suggestion the claimant had witnessed an accident, but rather what they had seen was the development of an illness. The judges noted that although there had been cases in the lower courts in which secondary victim claims in the clinical negligence context had been made and had even succeeded, none of those cases had ever examined in depth the question of whether, absent an accident, damages could be recovered. The majority then spent considerable time analysing Taylor and de novo. They began by commenting that that case had been correctly decided, and they specifically endorsed the decision of the Court of Appeal. They confirmed that the Court of Appeal in Taylor had been right to conclude that there had only been one relevant event for the purpose of assessing proximity, and importantly, they confirmed that that was the accident when the crates fell on the claimant's mother. The death was not a relevant event for the purpose of assessing proximity under Alcock. Further, the Supreme Court in Paul approved the Court of Appeal's reasoning in Taylor, namely that if the death had been capable of constituting the relevant event, it would lead to the bizarre situation where a claimant who witnessed the death of a loved one occurring weeks, months, or potentially even years after the initial accident could recover damages as a secondary victim, whereas if the victim of the accident had died at the scene and the claimant had arrived at the scene perhaps some hours after, that claimant would not be able to recover damages as a secondary victim. The majority in the Supreme Court explained that the lower courts in Paul had misunderstood the ratio of the decision in Taylor and de novo. The key was the existence of an accident. Therefore, it was held that whilst the Court of Appeal in Paul were right to conclude that the decision in Taylor and de novo precluded recovery by the claimants in Paul, the reasoning was flawed. Taylor and de novo was not, as the Court of Appeal in Paul had claimed, decided on the basis that the secondary victim needed to be close in time to the acts or omissions constituting the negligence. Nor had it been decided, as suggested by Mr. Justice Chamberlain, on the basis that there could only be one relevant event when considering proximity. On the contrary, the key factor in Taylor and de novo was that there had been an accident that the claimant hadn't witnessed. That was why the claim failed. The claimant had not been able to demonstrate proximity to an accident. The Supreme Court therefore confirmed that proximity to the negligent act or omission is not required in order to bring a successful secondary victim claim. For my part, this is clearly correct, and indeed in the Supreme Court the defendant confirmed it was not running the argument that proximity to the negligence was required, and it was accepted by all 7 judges that this was an appropriate concession. The undoubted wisdom in that approach is best illustrated by an example. Let's say some scaffolding was negligently erected and 6 months later a mother sees the scaffolding collapse onto their child, causing the death of that child, and the mother develops PTSD as a result. I don't think anyone would seriously argue that there ought not to be recovery in those situations because the mother wasn't there supervising the erection of the scaffolding. The majority in the Supreme Court also rejected the arguments put forward on behalf of the claimants solely in Paul that in order for a secondary victim to succeed, the event that they had to witness had to be the first manifestation of the damage that the defendant was under a duty to prevent. Again, it was found that that test fails to heed the need for an accident. The Supreme Court asserted that the fact that an accident was required was evident, as the decision in Alcock itself confirmed that witnessing an injury was neither necessary nor sufficient to establish liability in secondary victim claims. The fact that some of the claimants in Alcock had witnessed their relatives suffer injury did not entitle them to recover damages. Moreover, in his speech in Alcock, Lord Oliver had confirmed that a person could be a secondary victim even if the primary victim hadn't suffered any injury because the negligence hadn't hurt them. fear that a loved one had suffered injury was enough to found a secondary victim claim. So the Supreme Court reasoned that if witnessing an injury isn't required in accident cases, then the rules that applied in the accident cases cannot simply be extended so as to apply in those cases in which injury is witnessed in the absence of an accident. And when confirming why the need for an accident was appropriate, the Supreme Court relied on the three following matters. Firstly, an accident is a discrete event, so it's clear to work out what the boundaries of liability are. This, in turn, provides legal certainty. And they advise that in order to maintain this principle and ensure it continues, it's necessary going forward for lawyers to construe the immediate aftermath very narrowly. Second, witnessing an accident is traumatic. In dealing with these cases, the courts are tasked with drawing a line between those who can and those who can't recover. They commented that if that line is to be drawn, then it's logical to draw it between those who witness the ordeal of an accident, as it can't always be said that there will be trauma involved when witnessing an illness developed. And even where it is present, it will often be difficult to differentiate the different degrees to which it's there. Thirdly and finally, where an accident occurs, it can be difficult to distinguish between primary and secondary victims. You'll recall that a primary victim can recover for recognised psychiatric injury in an accident in the absence of physical injury. Therefore, why shouldn't a close family member who feared for that person's safety as opposed to their own recover for the same injury? So having held that the claims would fail by reference to the approach advocated by the claimants, as the case law established there was need for an accident in secondary victim claims, the majority in the Supreme Court then moved to consider whether, in any event, a duty of care was owed in the medical sphere. The Supreme Court emphasised that it is essential in a secondary victim claim to show that the tortfeasor owed a direct duty of care to the secondary victim. The claimants argued that in order to ascertain this, the court simply had to determine whether the Alcock criteria apply. But the Supreme Court said that was wrong. The real issue was whether the Alcock criteria, which do govern the question of whether a duty of care is owed to a secondary victim in an accident context, could be applied to determine whether a duty was owed to an individual in a clinical context, and they held that it could not. The majority then realised they had to go back to general principles relating to establishing whether one party owes another a duty of care, and had to see how that applied in the medical context. They emphasised that when deciding whether a duty of care was owed, reasonable foreseeability of harm alone is not enough. There also has to be proximity, i.e. some relationship between the doctor and the family member, which means that the former owes the latter a duty of care. Considering as a starting point for their analysis the relationship between a doctor and their direct patient, it was noted that the proximity between those individuals exists as the former has assumed responsibility for providing the latter with a service. Now, as has become de rigueur in clinical negligence claims in the Supreme Court, scope of duty reared its head, as it was accepted that sometimes it has been argued that the scope of a duty owed by a doctor to their immediate patient extends beyond caring for the health of just that patient. For example, potentially in cases where the patient has a highly contagious disease, the scope of the duty may include ensuring that they're not sent home to infect others. But the Supreme Court was unable to identify any English case in which this wider scope point had in fact been accepted. So turning back then to the claims before it was held that it could not be found that the medical professionals in these claims had assumed responsibility for the health of any of the family members, so that there could then be no direct analogy with the doctor-patient relationship that could be used to find proximity. Although it was acknowledged that the concept of control over an outcome, which is another matter that can give rise to proximity, could potentially exist, it was pointed out that in fact the degree of any control would vary greatly. For example, in Paul, the doctor had no control at all over whether the family members would have been exposed to the heart attack. It could have happened at any time. Whereas in Purchase, there was more control, as it was an ongoing obvious illness that the family member could witness. But nonetheless, there was a degree of risk and uncertainty. It was held that what was common to all the cases was the need to assess what the fundamental nature of the role of the doctor was and why it is that medical care is provided. Looked at this way, the Supreme Court found that the responsibilities of a medical practitioner and the purposes for which medical care is provided did not extend to protecting members of a patient's close family from exposure to the traumatic experience of witnessing the death or illness of that patient. They concluded that society would not reasonably expect the medical profession to shield them from witnessing the death of a close family member. Accordingly, it was found on this analysis that no such duty was owed and the claims were struck out. So where then does that leave claimants who want to bring claims as secondary victims in cases where the underlying negligence is said to arise as a result of medical error? Well, clearly, unless the claimant can demonstrate that medical negligence caused an accident, there is no prospect of any such claim being successful. Further, although the Supreme Court stated that by deciding the case in the way they had, it left open the question of whether there could ever be a secondary victim claim in a medical context where there had been an accident, in my view, the prospect of any such claim succeeding is extremely poor. This is because even in those scenarios, it's hard to see how any of the rationale as to why accidents were necessary to find liability would apply. These cases would simply reintroduce the type of uncertainty that the majority decision in Paul had sought to remove. The other key point that needs to be understood by claimants in clinical negligence cases is that the decision in Paul applies not only where the secondary victim claimant has suffered a psychiatric injury as a result of witnessing a relative suffer injury due to clinical negligence, but it also applies where their injury is physical, for example, if they suffered a heart attack on witnessing the death of a relative. These claims too are no longer viable. There is one category of claim, however, that should be borne in mind, and that's really in the context for mothers in maternity scenarios. They are primary victims, and primary victims can of course bring claims for psychiatric injury, firstly because they're owed a duty of care by the clinicians directly, and secondly because you don't need then to rely on the Alcock criteria and showing that there was an accident. And in the case of YAH and Medway Foundation Trust, Mrs. Justice Whipple, as she then was, confirmed that where, as in YAH, the negligence occurs when an unborn child is within the womb, even if the mother herself sustains no physical injury and the injury is solely to the child, that mother is a primary victim of the negligence and can bring a claim for psychiatric injury arising from the birth of her disabled child. Moving then to personal injury cases, although not concerned with personal injury cases per se, the effect of the majority's decision in Paul has been to redraw the Alcock criteria in the following ways. Firstly, a secondary victim must now show that there has been an accident that they have borne witness to. And the Supreme Court has defined accident as an external event which causes or has the potential to cause injury. It is not the injury caused by that event. Secondly, the Supreme Court confirmed that it is not necessary for a secondary victim to establish that their psychiatric injury was caused by a sudden shock to the nervous system. They held that this had not been necessary to the decision in Alcock and was in any event predicated on an outdated view as to the causation of psychiatric injury. It would be sufficient now for a claimant to prove that witnessing the accident which killed, injured or imperiled their loved one caused them to develop a psychiatric injury. They do not need to go further and establish that the mechanism by which that injury sustained was based on shock. And thirdly, the Supreme Court have removed the need to establish that the accident witnessed was objectifyingly horrifying. A claimant will need to establish that it is reasonably foreseeable that the defendant's negligence could cause injury, but they do not need to show that the accident they witnessed was horrifying by objective standards. And the Supreme Court explained that it was right to abandon this criterion as it required judges to engage in the invidious task of determining the relative scale of horror that should attach to various events. I would suggest that these modifications of the Alcock criteria are to be welcomed by lawyers on all sides, as it removes uncertainty from an already tricky arena. So following on from Paul, the criteria that one must now establish in order to show that a tortfeasor owed a duty of care to a secondary victim are a close tie of love and affection to the primary victim, proximity to an accident or its immediate aftermath in time and space, direct perception of the accident or its immediate aftermath, that the individual concerned suffered a recognised psychiatric injury which was caused or induced simply by witnessing the accident, and thirdly, that it was reasonably foreseeable that a person of normal fortitude may suffer a psychiatric injury due to witnessing the accident. So, although it's taken us a while to get here, it does appear that at last we have arrived at a point where we can, with greater confidence than ever, advise our clients with some certainty in the tricky area of secondary victim claims. Having said that it has become easier to advise in these cases does not mean it has become easy. And so for now, I hope that you have a greater understanding of the law in this area than when we first began. But as always, if you need some assistance or guidance on anything that we've looked at today, then the doors of all of us at 2 Temple Gardens are always open. Thank you very much.